As I told you at the beginning of the show, an historic decision by the Supreme Court could have ripple effects for years. The court ruled against the NCAA, saying it cannot limit educational perks for its players. Joining us to talk about it is our legal expert, Candace Kelley. Good morning, Candace. And Candace, I don't know if you heard me this morning, but I've been talking about this for years as a sportscaster, thinking that these NCAA players should be getting paid, especially in college football and college basketball. This is huge. But from a legal standpoint, Candace, break it down for me. What does this exactly mean for student athletes and what they can now receive?
Well, first of all, good morning, Mike and Sharon. The Supreme Court has said that the NCAA is in violation of the antitrust laws by capping educational benefits specifically. So we want to make sure that that's what we're talking about, educational benefits, whether it means including computers or tutoring, graduate school, or paid internship. Now the Supreme Court has said that they can receive these extra educational benefits that include even cash or cash equivalent awards, but again, based on academics or graduation. It all has to be based on education. NCAA has argued that lifting this cap would kind of erode their amateur model, and really that is what I see is going on here. Their model is being eroded as they are making major decisions that are coming up having to do with other things in terms of these athletes making money. But for decades, as you said, these student athletes and former student athletes have been fighting for this. Coaches and commissioners make millions, as we know. The industry makes billions. The students have been saying, what about us? They have their partial answer, at least for now.
Yeah, they've been used and exploited, right, Candace? And Justice Kavanaugh, who, Justice Kavanaugh, ripped into the NCAA, inviting so much more, it seems. Here's what he wrote in part. The NCAA's business model would be flatly illegal in almost any other industry in America, and they're not above the law. So is this a sign that the NCAA might face more in the future? And what is their future, really? Because they think they're the governing body, but it sounds like the states are for now, and it's not going their way.
It is not going their way. And Judge Kavanaugh had a very interesting opinion, as you pointed out. Now, let's realize he's a huge fan of sports. He tried out for the basketball team, didn't make it. He coaches his daughter's team now, so he's really invested in this, even outside of being on the court. And what he did by ripping into what the NCAA is doing is setting it up for the future in terms of any other decisions that might be coming down the pike and any decisions that the NCAA is going to be making. This is going to stand. This is going to echo in their ears, the NCAA, as they gather together to figure out what happens to these athletes in the future, because they know that the lawsuits are not only in the pike, more are coming, but even more will happen if the NCAA doesn't make the right decision according to what these student athletes want.
All right, well, once again, it's time to education. We'll talk about what it could lead to and the bigger doors that it can open in a second. But I want to get to the legislation that is being passed in a lot of states. I think 19 states right now when it comes to their likeness, when it comes to their image. How is this separate from that, Candace?
So what we know now, the Supreme Court, they ruled on a case that came up to them that dealt with only specifically educational benefits. This still leaves the question, what about athlete compensation in general? Let's say that an athlete has 1 million followers on Instagram and they want to make money, or they want to endorse a product in any way, shape, or form. What's on the table now and what Congress and states have been dealing with is the name, image, and likeness rules and laws that really have not been established. Like you said, Mike, there's several states that July 1st, they have decided that, yes, athletes in these specific states can make money off of their name, image, and likeness, what other people understand as endorsement deals. Congress has several bills on the table, but they've been stalled. But now the NCAA, too, is also making decisions soon about what to do with this name, image, and likeness. So if you look at what's going on in the states, there's already a trend to say yes to the athletes. If we look at the Supreme Court, we see that there was a unanimous decision, yes to the athletes in terms of educational benefits. So this really opens the door. I mean, it really opens the dam, right? The floods are flowing right now, and everything is going in terms of yes for student athletes and what they have been arguing for decades.
Wow, Candace, the
It is a
billion-dollar
wow.
industry.
Yeah.
I mean, it's just the exploitation. You know, people have called it, you know, a slave mentality. Slaves made nothing and faced horrific abuse. But this is a form of abuse too. And I'm gonna give you the last word on that, because as we reimagine the NCAA and the college athlete, I wonder what tomorrow holds.
Listen, the NCAA has been talking about how this is an amateur sport, right? That has been their argument all the way to the top, now to the Supreme Court. I hear you breathing and sighing, Mike, because I know that it is something that people just don't understand, and they are exacerbated at this thought. How can this be an amateur sport if we have billions of dollars making in the making? There's nothing amateur about this. They've also argued that, hey, this is something that the fans don't want. But listen, we have fans on the Supreme Court that have said yes to these student athletes. So I think that this is going to change the whole trajectory and what the NCAA should expect in the future from not only the Supreme Court, but any courts leading up. And they have to make the right decisions so that they won't have to fight legislatively in order to correct the wrongs that have been out there for decades. There's really no reason why this business model should be separate and apart, like Justice Kavanaugh said, than every single business model out there in the world. They are not above the law. And that is the takeaway message here.
I didn't realize
Look,
my sigh was so
reading
loud.
an article.
So loud. I'm sorry. Sometimes my emotions just
Well,
kind of come
it's
through.
palpable. Yeah.
My sigh.
But I mean, that's what happens.
Just sorry, Candace.
I read an article that talked about the average college athlete 40 hours a week practicing. Now you tell me what's left for studying.
And they still got to go to school.
If this was a minimum wage case, come on, Candace. If this was about minimum wage, somebody be in trouble.
Yep.
They still have to go to school. And before this, they couldn't even go to graduate school in terms of monies that they received. I mean, it is great to have a degree, but people want graduate degrees to be more competitive. You really cut them off. It's like you use them and then you just throw them away if you find no use for them. And this is happening all over because there are only some who make it to the big leagues. What about these other students? They need tutoring. What about an extra computer? But I think another issue in that when these floodgates do open, let's say that they do get compensation, then there has to be some care taken for these players, and that, okay, if I'm getting more compensation or endorsement deals, how do I deal with all of this money? Because as we know, once they get more money, more problems. And so they're going to have to deal with that aspect too, that if they have millions in endorsements from their Instagram or a sneaker deal, that now it kind of opens them up for litigation, opens them up, they become targets. So there are different levels of this that I'm sure we'll be seeing coming if this tide continues to go in the favor of student athletes.